authority over which Congress may supposedly delegate to someone else to fill up the details. Because once again, if you read the Constitution as opposed to the opinions of the Supreme Court, you find no answers to those questions. Or you find the opposite answer, in fact. Moreover, the Constitution neither specifies exactly what are always nothing but details, nor provides a rational means for determining what the supposed details might be in some specific instance. What might constitute mere details in someone's speculative estimation could turn out in practice to be very numerous, complex, and of weighty consequence, depending on the subject matter. For as the old saw has it, the devil is in the details. Right? So it should hardly be surprising that, contrary to what the Supreme Court may have imagined when it cavalierly created this exception to the non-delegation doctrine for mere details, administrative agencies over the decades since then have been armed with the authority to interpret the statutes which created them, to promulgate rules, regulations, guidelines, and other directives, to implement those statutes, to execute the statutes and regulations by means of investigations and prosecutions, and even to adjudicate in non-judicial tribunals purported violations of the statutes and regulations, all of which would seem to go beyond mere details. Now, proponents of the administrative state invariably invoke necessity. What do we know about necessity? That's the last argument of tyrants, right? Isn't that what I'm saying? The last argument of tyrants is always necessity. They say, we need necessity for this. And once again, we come to the Supreme Court, that famous case, Sunshine Anthracite Coal Company versus Adkins. You're all familiar with that. The Supreme Court rationalized sweeping delegations of congressional authority in the 1930s on the theory that they were necessary in order that the exercise of legislative power does not become a futility. And then in a later case, 1941, the court claimed that in an increasingly complex society, Congress obviously could not perform its functions if it were obliged to find all the facts subsidiary to the basic conclusions which define its legislative policy. The Constitution, viewed as a continuously operative charter of government, is not to be interpreted as demanding the impossible or the impractical. Continuously operative charter of government. We have another term for that in the law. What is that? The living Constitution, right? The thing that changes chameleon-like from day to day as political background changes. Now, statements such as these paint a rather defamatory portrait of the Founding Fathers. Apparently, when the framers granted only certain explicit powers to Congress, they were too dull to realize that they were demanding the impossible or the impractical of Congress. Apparently, they did not provide explicitly for delegations of legislative authority because they were too myopic to foresee that such delegations would be necessary in order that the execution of legislative power did not become a futility. So they needed the Supreme Court to interpolate the notion into the Constitution much later on in order to correct these childish errors. Worse yet, such statements from the Supreme Court amount to excuses for unlimited government, because they presume that every possible subject in an increasingly complex society lies within Congress's jurisdiction. That is, that the supposed complexity of society, which is largely a matter of opinion in any event, rather than the specific terms of the Constitution, determine the extent of Congress's power. But why should anyone ever presume that the supposedly complex economic and social problems which politicians try to involve the government in really fall within Congress's constitutional functions? The Constitution grants Congress no general power, in so many words, to legislate about what some people may consider to be economic and social problems, even if those problems are increasingly complex. Furthermore, America has been an increasingly complex society from the beginning. This didn't start in 1930 or 1940, right? So the particularly increasing complexity of modern times can no more expand congressional power than did the ever-increasing complexity of the past. If some power to deal with increasing complexity through delegation of legislative authority exists today in the Constitution, it existed when this country began. And if not there then, it must be absent now. Moreover, if Congress cannot marshal what the Supreme Court denoted as all the facts subsidiary to the basic conclusions which support the defined legislative policy, must not the proper conclusion be that such a policy lacks a sufficient basis in fact to be legislated in the first place? Right? If they can't figure out what to do, then how can they do it? Another one of these circular problems. If it is impossible, if it is impracticable for Congress to enact specific legislation on some subject, Must not the proper conclusion be that such a subject is simply beyond the actual constitutional authority of Congress? And in both cases, must not the inevitable inference be that a purported delegation by Congress to an administrative agency of a power which Congress itself is incapable of exercising is not a delegation of an existing congressional power at all, but instead is an attempt by Congress to create an entirely new power for that agency? Well, I don't have to answer those questions because they're self-evident. Congress, of course, is the source of the administrative state. There's always some statute lurking in the background that has created one of these agencies. And the executive branch, to a certain extent, is a major participant in it, because many of these agencies operate, at least titularly, within the executive branch. But what about the judiciary? Well, in the course of the steady and systematic development of the administrative state, a familiar pattern has emerged. And you see this in other areas. First, the Supreme Court has injected a false principle into constitutional jurisprudence. In this case, the loose concept of filling in the details. That's the first thing. They blunder. They make a big mistake. Second, over the years, various beneficiaries of that false principle have acted upon it, of course, greatly expanding its reach and its effect step by step, presumably far beyond what the Supreme Court may ever have imagined originally would happen. And then third, rather than admitting its initial error and correcting the first problem, the Supreme Court in later years attempts to mitigate the damage that the false principle causes by somehow regulating the application and use of that principle to minimize its misuse. That's the old concept of closing the barn door after the horse has escaped, right? Thus, in various of its opinions, the court has evinced the position that although Congress is manifestly not permitted to abdicate or to transfer to others the essential legislative function which is vested, a delegation is supposedly constitutional where Congress has stated the legislative objective, has prescribed the method for achieving it, and has laid down standards to guide the administrative action. It's very interesting because, once again, when you read these opinions, the Supreme Court is using non-constitutional terms as the measure of constitutional authority. Instead of declaring delegations to be always invalid on the basis of a fixed constitutional rule with a basis in the words of the Constitution, the court decides whether a delegation is valid or invalid based on its interpretation and application of terms which are not to be found in the Constitution at all. When the court refers to intelligible principles, by what reading of the Constitution are such principles to be determined to be intelligible? When the court goes on about standards of legal obligation, which Congress may have set out in the statute, what constitutional standards are to be applied? Well, once again, these are questions that never find an answer. The court makes this up as it goes along. What are the principles if they're not constitutional? Well, they're political and invented by the judiciary. Well, actually, there was a case that attempted to lay down a rule, American Power and Light Company versus SEC, 1946. Congress reiterates all of these ideas about legislative standards and principles and so forth and so on, and it says that the remedy, the ultimate remedy, is that private rights, that is the rights of individuals who are affected by what these administrative agencies do, private rights are protected by access to the courts to test the application of the policy in the light of the various legislative declarations of standards and so forth. So the rule here, according to the judiciary, is that Congress is to set up standards based on intelligible principles so that the agencies can determine what are the mere details in the legislation, and then, if something goes wrong, the victims of this are to go into the courts and have the courts vindicate them in some sort of judicial proceeding. The problem in practice, however, is the determination of whether all of these principles are sufficiently intelligible to operate as standards will always be made by the agencies in the first place. These questions don't come before the courts in the first place. The judiciary becomes involved only when the agency's determination somehow becomes the subject of litigation. And how often is that? Well, if you practice in this area, you understand that litigation will not always, and indeed not even usually, follow an agency's actions. In how many cases has the Supreme Court, let's take that as the classic example, in how many cases has the Supreme Court actually enforced these various standards one way or the other? In how many cases have the courts in general been called upon to do so? In fact, in how many situations could they be called upon to do so, given the amount of work that these agencies do from day to day? Very little of their activity could possibly come before the courts, and if only because most people who are affected by the agency's actions really can't afford to litigate the matters. So worse yet, when the litigation does ensue, the courts have adopted a rule by which they defer to the agency's supposed expertise. We come back to that point, right? The agencies are experts. We're just the judiciary. We don't know anything about this, so we have to give them, in essence, the benefit of the doubt. We defer to their expertise. Whether this is a matter of an agency's interpretation of a statute or of an agency's finding of fact. So when the agencies act quasi-legislatively, the courts say, well, you have more knowledge about this statute than we do, so we're going to accept your interpretation unless it's so ridiculous that no reasoning person would accept it. And when you act quasi-judicially in an administrative hearing of some kind, we're going to accept your interpretation of the facts unless, once again, it's beyond the pale of reasonableness. So what's the overall effect of this? Well, Justice White observed in a case called INS versus Chadha in 1983, not that long ago, that, and I quote, "In practice, restrictions on the scope of power that could be delegated diminished and all but disappeared during the 1930s. So the effect of it is, yes, they've set up this house of cards of judicial oversight, but the reality of it is that its effectiveness is essentially nil. And you might ask the question, well, why did that happen? The same reason has happened in many other areas, where the court has invented these houses of cards where it pretends to protect rights of various kinds, and then in the real world it doesn't, because the justices are in favor of this type of a setup. They want an administrative state in this country, but they want to give you, the average American, the impression that they are in control of it and somehow you are protected by the judiciary when in fact you are not. And I don't think that there's any lawyer who has ever practiced in this field or in the constitutional field that in a moment of lucidity and honesty would not agree with that point. Right? Most of them will disagree for another reason because they want to keep their careers going, but if they're honest about it, they'll tell you that. Now, actually, the administrative state amounts to far more and is far more dangerous than what you'd call the typical ideological nostrums of politicians and judges. This is because it is not merely a happenstance composite of details cobbled together on a hit-and-run basis from odd congressional delegations of authority over the years. Rather, it is an intentional and systematic transmogrification of the form of government which the Constitution prescribes. Its purpose and effect have always been to defeat the Constitution in particular and popular representative government in detail. Now, one might say, well, that's a serious charge. But it's a charge easy enough to prove. Let's go back to the original founding document, Declaration of Independence. Declaration of Independence characterized the misbehavior of King George III as, quote, a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over the American colonies. And among the acts which may define a tyrant, the Declaration excoriated the king for, quote, altering fundamentally the forms of our government. Well, when the Declaration was published in 1776, the universal understanding was, I said earlier, a delegated power cannot be delegated. And just 12 years later, in 1788, the Constitution applied this principle threefold in the articles which provide that all legislative power shall be vested in Congress and all executive power in the President and all judicial power in the judiciary. Yeah. So, if we look at the administrative agencies in general, and certainly at the administrative state, we would say, well, this system has altered fundamentally the forms of our government. And in fact, in a case decided in 1952, Justice Robert Jackson, remember he was the prosecutor in Nuremberg, Attorney General of the United States, Justice of the Supreme Court, under Roosevelt, prosecutor of the Nazi criminals in Nuremberg. Justice Robert Jackson candidly informed Americans that administrative agencies, quote, have become a veritable fourth branch of the government which has deranged our three-branch legal theories. But given that our three-branch legal theories perfectly reflect the very structure of the Constitution based on the plainest text on the face of the document, and therefore are facts, not theories, precisely how is a fourth branch of government, and especially a fourth branch of government capable of deranging the Constitution, legally possible?
Croc TV.